Welcome committee members, liaisons, and members of the public to the Legal Services Trust Fund Eligibility and Budget Committee meeting. Thank you for joining us. We will begin shortly. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to make a comment during the meeting, please type "I have a comment" or "I have a question" in the chat, and a message will be sent to the host. Alternatively, you can use the raise hand feature. In efforts of transparency for those joining this public meeting, whether by Zoom, by phone, or by Zoom, we request that you refrain from having any side conversations in the chat about the content of the meeting. Again, the chat feature is utilized simply as a tool for you to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. Moving forward, this meeting and all committee meetings will be recorded and posted on the State Bar's website. As a friendly reminder, this is a video conference meeting, and please be aware of your surroundings behind you. For those joining Zoom on computer, when on mute, holding down your space bar will temporarily unmute. If you use your phone to dial into the meeting, please be sure your computer's microphone is on mute to avoid audio feedback issues. While joining audio via computer is highly recommended, if an individual loses audio, they can they can call in separately using the Zoom conference feature. Thank you.
Thank you, Kim. Erica, do you want to do a roll call?
Connolly?
Present.
McCloskey? Fightmaster? Bennett?
Present.
Lakemore?
Yes, present.
DeBose?
Here.
Delfino? Friedman? Mann?
Here.
Meeker? Meeker?
Here.
Yeah. Lantold? Bob, are you there? I see Bob on the call, but Savage? And then sorry.
Who was the last one?
Kim Savage.
Here.
Oh, Bob said unmute him. You are unmuted. At least we see you unmuted, Bob. It might be a glitch in the system. I've noticed this happen. You might have to call back in for it to stick. But I think we can mark him as present, right?
Hello, finally.
Oh, there.
Yeah,
There you go.
here.
Great.
And then I'll go through liaisons and State Bar stuff. Selena Copeland.
Present. Morning, y'all.
Bonnie Huff.
I'm here. Thank you.
Christine Ganon. Mark Tony. John Nguyen. Michael Chang.
Present.
Brady Dewar.
Great. Do you have quorum?
Yes, we do.
Okay, great. So I'm going to do a call for public comments, but Ms. Joe, I see your chat and I know that you're available to discuss the Asian Americans Advancing Justice issue. My suggestion, if you're amenable, is if you can sort of wait and let us take a couple of the other pieces of agenda, and then if you can, we can then discuss that matter with you present on the for discussion. Would that be okay? And you can make your statement at that time. Okay, in the chat she says, sure, no problem, I'm happy to wait. Thank you, Ms. Joe.
Erica, just sorry, I should have sent you an email. Brady has some time limitations, so could we do that item first in the first 15 minutes? Because he has another big meeting.
Oh, yes. If the committee is otherwise amenable, we can take that first thing and then do our updates after. So why don't we go ahead and consider advancing Asian Americans Advancing Justice's I guess, request for reconsideration. Is that okay? Nobody objects to us taking things out of order? Okay, hearing no complaints. Erica, do you want to give us a preview of what we're discussing, and then we'll let Ms. Joe make her statement?
Sure. At the committee's last meeting in May, we reviewed impact litigation and advocacy work activities. One of the reports that was reviewed individually was Asian Americans Advancing Justice, LA's California Census and outreach work. The committee reviewed that report and raised some questions, both as to whether the activity could be considered a legal service, as well as whether it was primarily for the benefit of indigent persons. And after discussion at that meeting, found that particular activity to be non-qualifying, meaning that the organization would need to deduct it on its 2022 ILTA application as a non-qualifying expenditure. We informed Asian Americans Advancing Justice of that decision and invited them when they asked for reconsideration to attend the meeting, and they also submitted a written comment regarding those aspects of the legal services component and the focus on indigent persons, and that was included in the meeting materials. So I believe Connie also has a public comment to make regarding that.
Great, thanks, Erica. Ms. Joe, if you want to make your statement, and if you don't mind also maybe staying available to answer some questions that the committee may have.
Absolutely, I'd be happy to. And thank you so much to the committee for allowing me to make this public comment today. I'm the CEO of Asian Americans Advancing Justice Los Angeles, and I want to explain how our organization's census activities are both legal services and targeting indigent clients. The work was supervised by Vice President of Programs Anthony Rowe, who is a California State Bar licensed attorney, and our statewide census activities centered on advocacy. And we led a network of statewide partners whose on-the-ground outreach targeted towards hard-to-count Asian American, Native Hawaiian, and Pacific Islanders informed that advocacy, defined not just by indigency, but also limited English proficiency and immigration status. For example, we intentionally partnered with the Fresno Center because of their track record penetrating the Hmong community and the Empowering Pacific Islander Communities organization to reach the Tongan community in South LA. Our 2010 census data shows that 2/3 of the state's Hmong community and 78% of LA County's Tongan communities were indigent. When we learned of the challenges our grassroots partners faced, we advocated for policies to the state census office and the US Census Bureau to ensure sufficient resources were allocated to engage hard-to-count communities. This included uplifting policies that improved language access, cultural competency, and motivational messaging to penetrate these communities. We regularly provided talking points in language to the state census office that they ultimately adopted to craft messages that would best reach these communities, especially due to the pandemic and misinformation related to census confidentiality and immigration status. Advancing Justice LA took great pains to target hard-to-count API communities who are often at the nexus of being low-income, limited English proficient, and immigrant, because neither the US Census Bureau nor the State Census Office covered materials in Thai, Samoan, Nepalese, Bangladeshi, or Lao, communities that are each over 70% indigent. We advocated to the State Census Office to fund in-language materials for communities, which was done. We know that because of the model minority myth, the true challenges and needs of our indigent and especially underserved API communities are overlooked. Having accurate census data for API communities is a powerful tool that not only helps to dispel this myth, but it helps us identify communities and substantive areas of needs, which better informs our legal services. Finally, our decennial census work lays the foundation for our demographic research activities, which have previously been deemed qualified. Our demographic reports, which is where I pulled the data describing the Hmong and Tongan communities previously, disaggregate census data by API ethnic community. So you can see how these groups compare to one another, as well as how they compare to other racial groups. And I'd like to finish with the story about why we are so committed to getting the census data right for our indigent API communities, so we can capture that information for our demographic reports. Prior to joining Advancing Justice LA last August, I served for 12 years as the executive director of a Korean nonprofit in Los Angeles that served over 100 Korean domestic violence survivors annually. Our clients were 90% limited English proficient and overwhelmingly indigent. Even then, I used Advancing Justice LA's demographic reports when advocating to LA Superior Court to provide more Korean interpreters at restraining order hearings. That report had 2010 census data from LA County that showed 72% of Korean Americans were foreign born, 55% were limited English proficient, and the average per capita income was $27,838. The reason I had these powerful statistics when advocating to the courts for language access was because Advancing Justice LA had been so diligent in the 2010 census to reach hard to count Korean immigrants. Advancing Justice LA prioritized Koreatown, where more Korean immigrants resided, and partnered with Korean Resource Center there, which we did again in our 2020 census. So I want to thank you very much for allowing me to share this comment with you, and I hope the committee will reconsider its determination that Advancing Justice LA's state census work was a non-qualifying activity.
Thank you, Ms. Jo, very much. Do any members of the committee have questions for Ms. Jo? Well, I actually do have a question, if you don't mind. So you said in your letter and in your statement now that you guys had, that your organization had advocated for policies to kind of increase resources due to the fact that there were challenges with reaching hard to reach populations. And I'm curious if you could give me a little bit more specifics on what that advocacy looked like.
Sure, I'll get that started. And then if you don't mind, I have my colleague, Janet Guan, who is here as well and might add in some more information. The one area of advocacy, for example, is we know in California, the Asian American, Native, Hawaiian, and Pacific Islander community speaks more than 40 different languages in this state. Now, the state census office provided Asian helplines for census in 6 Asian languages. What we did is we advocated to the state and worked with our partner organizations to ensure that there were materials in at least 15 different API languages. So for example, as I mentioned with the other group of, as I mentioned in my statement, the Hmong community in Central California is a particularly underserved group in that region. Languages were, that community was not provided with translated materials by the state census office. So we went the extra step, working with our partners to make sure census materials were available in Hmong.
Great.
Hi, may I ask a question, sort of clarifying?
Sure, and then Kim also had her hand raised, but yeah, go ahead.
Sorry. So that's as I look at this, I'm hoping for a little bit more detail because in your answer there, I noticed, you know, I think it's pretty clear if you're writing letters to the government and you know, citing their law and making an argument that certain services should be provided under the law or under the policies, that's advocacy within our definition. But where I think it's not is, it sounded like you were saying that when you described that project, you were counting not only the advocating to the government, but then working with your partners to actually create the materials and do the what's really more community organizing work. And I wonder if you can, you know, delineate what was actually advocacy to the government and what was doing the work. Were you spending, you know, these funds to create materials, to go door to door, to actually do the outreach, which wouldn't be legal services under our definition?
Well, I think what it is that it's not just about translating materials. It's about advocating to the state that these materials needed to be translated and that the state needs to have that available in language. It's really hard with the API community to sort of separate the language access needs and the advocacy and the policy work that goes around that. And so the way I see it is that when the state did not have those language services available, it's not that we just went ahead and translated it and distributed. It's what we did is we advocated to the state to say, this is important that these this materials is translated into these particular languages. And the reason why is this, because, you know, when you look at the numbers of people who speak these languages, often they're not big enough for the state to recognize them as being important. But that's where our advocacy comes in, is that we explain to the state and we uplift certain communities in certain regions that are particularly underserved. And we say to the state, it is important that you allow these materials and to be translated, and that you support that translation and language access. And so I think it's hard to separate that advocacy from the actual language translation that was done, because it's not just that we do it, it's that we need the state to recognize that this is important in order to reach the most underserved members of our community, and that the reasons why those communities are underserved and they're not penetrated unless we do that work.
Thank you, Ms. Joe. Kim, did you still have a comment?
Yes, I just first want to say that I think this is terrific work. And, you know, putting aside statutes and regulations, it's really important work. I'm trying to understand whether your work was motivated by any potential legal claims. I understand the advocacy. I worked on similar things like this with the Social Security Administration, but and we didn't sue. But I'm just curious if, from your perspective, if you're able to comment on whether were there legal claims which kind of frame potential legal claims that framed the work that you've been doing.
Yeah, I would say whenever we're talking about language access for our communities and policy work, it always has a potential legal claim. We very much look at how language access and language justice and the failure to provide that may have an impact on our most underserved communities. And so we've had quite a few lawsuits in the history of Advancing Justice LA where we have sued, whether it's government or private actors, with the action being that certain languages materials were not provided to our communities in language, and therefore our community members were denied privileges and rights. So in this particular case, I can't say that we had been working on, let's say, a legal brief in preparation to take action against the census, but I will say it has been always part of Advancing Justice LA's work to look at language access as one of the fundamental rights for our clients, and our communities, and that we have multiple examples of lawsuits that we have filed in the past for language access.
Thank you. Thank you for your answer.
Zira, you have your hand raised?
Yes, thank you. And, you know, thank you for the conversation. I just want to echo what Kim also shared. I do think that this is very important work. And that, you know, thank you for sharing it with all of us. I do want to get back to what Brady was sharing in terms of this disaggregation of activities, because that particular piece of like, what is the advocacy activity and what are the other activities that are also important activities, but do not fall under the definition of legal services. And that is sort of like that separation and disaggregation, because a number of groups, as you know, engaged in census related work, especially for hard to count communities. And it happened all up and down the state. Some of them were by legal services entities, probably, and many were not by them. And so I think my secondary question to all of this with respect to, just the commission more broadly, is if anyone else kind of sought this type of further consideration from us in terms of census activities being deemed as legal services. But I do think that there's an important distinction between the advocacy work that's occurring and all of the other census work. And I question whether the fact that an attorney was engaged in the activity that's not advocacy related work then brings it under legal services. The fact that an attorney is carrying it out doesn't change the nature of the work in terms of who's supervising it if it's still not legal services. So I do think that the distinction between the advocacy and the other activities is important. And I would like to see a disaggregation of that if we were to reconsider and move something else forward.
Erica, Carol, do you want to take that question from Zahira? Because we did, at the last meeting, I believe this committee found another similar activity not qualifying that census work. So if you had choose to find advancing justice, we would need to be consistent and then let other program know that that's from my memory, but Erica, you might have more.
Yes, I believe that there was one from California Rural Legal Assistance that was found non-qualifying, and it was census related as well. I don't remember off the top of my head all the details of that activity, but I know the primary focus was the census, and I think it was a similar situation where it wasn't clear how much was sort of more organizing and outreach versus legal services.
And that organization, we did notify them and they have deducted it in their application. I guess a follow-up to Zahira's question is, Connie, are you guys able to disaggregate that the advocacy piece that we would consider non-legal services if we allowed the other piece? Like how much qualified expenditures are we talking about here?
I think we can try to do that. I think I hear what you're saying. I think the challenge here is even the strategy and the outreach of who we selected as partner organizations to work with to do this is part of our advocacy, because we choose partners that we know are really on the ground who can penetrate those communities. And then in the same way that our community members that I was mentioning have are underserved, often our partners are themselves run by individuals who are limited English proficient, immigrants who have a harder time sharing, putting their voice out to the state. And so part of our strategy is to take what they tell us, uplift what they share as their concerns on the ground, and then bring that to the state census. So when we went to the state census office and said, look, these are some of the challenges when we're talking about the Tongan community, and this is what we think you need to do to really reach the Lao community. We do that because we have these, we are basically advocating on behalf of those organizations who give us that feedback. So it's a little bit hard to separate what we're doing with those organizations who are on the ground doing the outreach.
Connie, let me ask it another way, just so that it's not as abstract to at least myself. How much qualified expenditures if you did not disaggregate it?
How much qualified expenditures we have?
How much are you're seeking to claim this as qualified expenditures? So how much expenditures in 2020 would you like would you like to be qualified? What are we?
Yeah, the dollar figure is around $800,000.
Okay, and your organization's total corporate expenditures are?
Last year it was about $10 million.
Okay, so it's a sizable amount.
Yeah. So sorry, Oh, Zahara, you get, sorry. Zahara, go ahead, and then Jim, and then I'll make my comment.
Oh, no, I mean, I think that it's a helpful illustration in terms of knowing the amount. And I think that's also the reason why, in terms of having that level of disaggregation, is really important. I think that, for a number of us who've been attorneys, we understand that there are different stages of which you're engaging with people and how something is worked up. I don't know if the way in which they track it, if that's trackable in terms of the number of hours someone spent engaging with an entity that they were partners with, and then help them in terms of writing the letter. But I do wonder, because it's as something that attorneys do all the time, is if it's something you can disaggregate your activities, because there are a lot of those census activities that happened a lot all throughout the state, again, by a number of different entities that just don't fall under the because they don't fall under the definition of legal services. And I think that in terms of, again, like the fact that there was an attorney who was managing the work doesn't change the nature of the services. And I do think that there's also the piece around, and I've kind of said it before in some of our work, like with equity, is that once we kind of open the door in a specific situation where if we're going to change the nature of something, there may be other organizations that engage in that activity, but they didn't request the funding from us, because a lot of organizations did census related activity because there was a huge push for that, especially for underrepresented communities. And a lot of the legal services organizations, that's who they're working with. We're working with some level of underrepresented, hard to count community that they would have then been maybe doing some other layering of work with.
Thanks, Zahara. Jim?
Yeah, I've been thinking about this, especially in light of the expungement issues, and I approach this from a slightly different perspective as a social scientist and not as an attorney. But as a long-term member of the Access to Justice Commission, language issues has always been a primary concern, and we've generated a number of reports on that. Accurate census data is a primary issue for us. That's how we allocate funds. That's how we determine how many poor people are out there, how it's distributed across the state. And the purpose of this stuff is in order for them to get resources. And I think that's an important part of the advocacy. The same thing with this expungement, although technically I see where that's defined as criminal. But the reason why you expunge a record is so you have access to other things such as housing, government benefits, and other things that our organizations routinely advocate on. So thinking about that, thinking about what our prior discussion on the other people doing census work, I've come to change my mind on that. I think this is important stuff. Now, I realize the comment that opens the gates to other organizations, and maybe we need to get a little bit more technical in terms of how we define the advocacy as opposed to merely translation work or providing translated documents. But for me, and again, coming from a non-legal perspective, I see this is critical stuff.
So before I go to Catherine, let me just say, and I think we've had this a couple of times, I don't think, even if we ultimately uphold our decision or uphold it in part, I don't think there's anyone on this committee that doesn't think this work is very important. I think it's all coming down to, like, does it all qualify as legal services, whether or not it actually benefits people more, the community more generally. So Ms. Joe, I just want to clarify, we are very impressed with the work you guys are doing. That's not at all that's not the assessment we're trying to make here. So I just want to make sure that's clear. Everyone, I think, agrees that this is very important work. So anyway, Catherine, go ahead. You're actually on mute still. Sorry.
No, I always think I can do it from the screen, and it seems like it requires you to go down below. So I apologize. So I agree with everything that's said about the importance of the work. And I was interested in the question that Dwan was asking about how much money is being claimed, which was, sounded like $800,000. And is that the amount that's claimed for your organization, Ms. Joe's staff time? Or so what are the natures of that, of those expenses? Is that for the translation of materials? Is it for contracts that you had with some of these community partners? Is it just staff time? It would just help me sort of understand what the mix of things are that are within that 800,000.
Sure, and if you don't mind, may I answer both Ms. Blakemore's question as well as respond to a couple of the other comments together?
Yeah, absolutely.
So first, the 800,000 includes the cost for all of us in our census work, including our organization's staff time, the translated materials, and our subcontracts. It's the entire body of that census work. I also wanted to go back to Ms. Savage because you had asked about the language access and if we had considered litigation, and I had mentioned that we have a history of considering litigation and looking at that language access, and a large body of our litigation work does revolve around language access. And so I wanted to give one example, such as when we worked on a class action lawsuit against Medi-Cal, and that involved language access and requesting that for certain Asian American, Native Hawaiian, and Pacific Islander communities. So I just wanted to give a specific example of how we have done that before. And I appreciate what the committee is saying in terms of your recognition about the importance of this work. But what I'd like to kind of underscore, it's not just that the work is important, but how important it is for Asian Pacific Islander communities to advocate and use our advocacy skills and use as lawyers at Advancing Justice LA, and do that to really dispel that model minority myth and really pursue language justice. Those are cornerstones for legal services for Asian Pacific Islander organizations. Especially now, I think the reason why I really have pursued this with this committee instead of letting it drop was, quite frankly, I think it's so important that we finally push through that model by minority myth that has been so has been such a barrier for our community. And I see it now, especially with the rise in anti-Asian hate, that I can't let it drop, that I cannot allow any opportunity where I can advocate and say that our community continues to be allowed to be to let that be dismissed. And to me, our census activities is one of the most powerful tools we have to dispel that model minority myth. And so we advocated for that with the Census Office in all the ways that we could. So I just wanted to underscore that point.
Okay. Thank you, Ms. Joe. I think at this point I appreciate the comments that you made. And one thing I will just highlight, and I sort of turn to Brady on this, is like, I completely understand your point that the information that you get from an accurate census data is very powerful, like data for future advocacy work. I think the real question is, are you getting that data through legal services means, or is it through non-legal services means? And so that, and I that's just the question that we have to kind of grapple with here. And so Brady, if I'm saying that incorrectly, please let me know, but I wanted to just make sure we kind of kept that a little bit clear. Dwan, you had your hand raised?
Yeah, if I can make a suggestion, because it seems like if I'm reading the room that we might need a little bit more information. If staff can have authority to work with Advancing Justice to the best extent that they can itemize the 800,000, I think that might help us get to a closer, it seems like some of this might be qualifying and some of this might not be under our definition, so that they wouldn't need to deduct the whole 800,000. I think that might ground us for our next meeting.
Great. Ms. Joe, hopefully you'll be amenable to that as well, but I think that's probably the best plan going forward. It sounds like there is some stuff, and we really appreciate you coming in and providing us with more information about this that would be qualifying. We'd like to obviously include that. So is this something we need to take a vote on? No? Okay. Does anyone have any objection?
Do we need to take a vote, Brady, on that? We don't, right? Oh, you're on mute.
You're still on mute. But your hand was raised briefly.
I was trying to raise my hand. I was just going to suggest, no, I don't think any vote is necessary. But to the extent possible, focus. I think we all understand why everything is important, but I think we need to focus on what the actual activities being funded are. So is this communications with a government decision maker or a tribunal versus on the ground census work?
Yeah, and Brady, I think that's where I think the itemization, because I heard that there were some contracts, and so we can get to kind of like what the nature of those contracts are. Staff, yeah, we could probably get to a little bit closer. I don't know if it'll be an exact figure, but you know, it'll be based on something.
Okay, well, it sounds like we will go ahead and allow, unless anyone has an objection, staff, we'd really appreciate if you'd work with Asian Americans Advancing Justice to get some more information about the details of the expenditures. And then, you know, obviously when we will revisit this, Ms. Jo, if you want to come back and provide us with, you know, more statements at that time, we welcome you coming and providing us with some information, additional information. Okay.
That sounds great. Thank you very much.
Thank you. All right, let's go ahead and move back to the agenda. And I think at this point we need to actually approve our minutes from last time. So Erica, do we have any discussions, concerns, or questions about that, about the meeting minutes from last time? Hearing no issues, I think we can move to a vote. Can someone, make a motion?
Catherine moves approval.
Great. Do you have a second?
Second.
Okay, Jen's seconding.
I'll take roll. Connolly,
Yes.
Aklagi, Fightmaster,
Yes.
Bennett,
Yes.
Blakemore,
Yes.
Rose,
Yes.
Delfino.
Yes.
Friedman, Mann.
Yeah.
Meeker,
Yes.
Wenthold,
Yes.
Savage.
Yes.
It's approved.
I assume motion passes.
Sorry, you didn't hear me. I said that, yeah.
Oh, sorry. I might have just not been hearing it. Okay, updates on the Heart LA.
So we had an organization, Heart LA, which was a first-time grantee in 2020, a small organization operating in LA County. They applied for 2021 funding, but eventually declined their award. So we have been working with them over the past few months to get their reports in. And the past few weeks, we closed out all of their fiscal quarterly reports with a complete spend down. And their evaluations, it looks like they closed 48 cases in 2020, and they had sort of a niche focus on housing issues faced by tenants with pets. So just an update that they are no longer a grantee, but that we are satisfied that they've complied with all of their requirements under the grant.
Great, and thanks to staff for being determined on getting that closed up.
Yeah, no problem. And then we did have some updates on other evaluations that are late. So family legal assistance at Chalk Children's has some outstanding evaluations that we've been requesting that they submit. So they're missing their Q3 and Q4 reports from 2020, their case summary reports, their EAF evaluation, and yeah, might be it as far as the reports, but we are working with this organization and may speak about them a little bit more later related to some of the other items on the agenda, but that is the one organization that has outstanding evaluations.
Any questions or concerns from the committee on these updates? Okay, and on the missing evaluations, you'll let us know if there's anything, you know, broader impact or anything that we will need to make determinations on.
Yeah, so their Q3 and Q4 reports are consequential to their ILTA application because they have a fiscal year that runs through December 31st. So we will need that in order to make sure that we've got the right ILTA and EAF spending from 2020 on the application. So that will be consequential if we don't get it during the course of the application review.
Okay.
So I just want, since I'm relatively, sorry, it's Catherine, I'm relatively new to this. So, I mean, I'm always troubled when there's consequential things that are not submitted timely. And so I mean, I assume the state bar is as well. I'm not suggesting otherwise, but like, are there options that we should be considering? And it just seems important that documents be submitted on time for, you know, the work that was done. And I guess I just wanted to flag that it is concerning to me that it's not just one report, or it seems like it's several reports. And what if anything, would you advise the commission we should be doing about that?
Yeah, so we are recommending that the chair of the committee actually meet with that organization. They have an audit extension request pending, but it's unclear until exactly when they'll be able to submit their financial review. So I think also as part of that conversation, we would recommend discussing compliance with the grant requirements and possible consequences. My understanding is that the director of that program reported having some recent health issues. I don't know the extent of that or how long it's been going on, but I think we would want to get some more information. And it's also a very small program. I believe they have 2 attorneys, if I remember correctly. And so I think having a candid conversation about the requirements, as well as finding out if they need support in any way from us to help them before taking action would be appropriate. But I think if it became a pattern, they're a newer grantee. If this was sort of a continuing issue, then that's something that might be a flag for an eligibility review conference. But
okay, I mean, I support doing that, and I saw it in the proposal about the late audit, and so it's reassuring to have it be a broader discussion, I think, just so that we're carrying out our responsibilities of making sure that there aren't other red flags that we should be aware of.
Okay, and it sounds like we'll talk about them a little bit more as we go through the rest of the agenda items. So if we have other concerns or comments, we can discuss at that point. Should we move to the remaining 2020 ILAW activities from Disability Rights Legal Center and National Immigration Law Center?
Sure. So at the last meeting, the committee reviewed activities from Disability Rights Legal Center and National Immigration Law Center. And there was a request to follow up with these organizations to get some more information about the activities they were reporting, because it wasn't clear to the committee in some instances whether it was qualifying. In the case of NILC, you know, whether the direct services would qualify because they were working out of state. And so we were inquiring whether the organization they partnered with would be essentially a qualified legal services project equivalent, or private attorneys providing pro bono services. When we followed up with NILC on that, they reported their partner organization was the Council on American Islamic Relations, and staff did some more research on that organization, and they do provide legal services, but it wasn't our estimation that they would be considered a QLSP if they were to operate in California. And so we let NILC know that, not that we were making the decision, but that was kind of our analysis. And they decided at that point that they didn't want to proceed with review of the activity, and they voluntarily chose to mark it as non-qualifying. So that is no longer needing committee review. That's just sort of the status update on their activity. And then with Disability Rights Legal Center, they had a cancer policy advocacy activity where they cited support for Covered California Affordability Act, Lymphedema Treatment Act, and the Paid Leave Act. But there were a few details in the report to understand sort of what activities they undertook to support that legislation. We followed up with the organization asking for more information, and we didn't receive a response, and the organization had said that they didn't know if they would be able to get back to us in time, and we didn't receive further information. So they didn't affirmatively say that they would deduct it. So it's our opinion that the committee would still need to vote on that, but we would recommend finding activity non-qualifying since we don't have additional information to provide.
Does anybody have questions or comments about disability rights legal centers activities? Okay, did I hear anyone? No? Okay, well, given that we had some questions and they didn't provide additional information, it seems as if we should, I assume the committee is on board with adopting staff's recommendation. Would anyone like to bring a motion?
Catherine moves to adopt the staff recommendation to require them to deduct that expense from their application.
Great.
Second, Bob Plungle seconds.
Thank you, Catherine and Bob.
Connolly,
Yes.
Maflagi, Fightmaster,
Yes.
Bennett,
Yes.
Blakemore,
Yes.
DeVos,
Yes.
Delfino,
Yes.
Friedman, Mann,
Abstain.
Meeker,
Yes.
Lantold,
Yes.
Savage.
Yes.
The motion passes.
Great. Okay, we already discussed the Asian Americans Advancing Justice request for reconsideration. So let's go ahead and move on to the update on other ILAW activities.
Yes, so I might have mentioned at the last meeting that we had some ILAW reports that were still pending because they touched on topics like expungement and fines and fees, and that was a topic that's coming up for commission consideration later today. We did another review of those activities that we had and found them to be qualifying. They were more in the nature of advocacy, not representation in a criminal proceeding. For example, there were some amicus briefs filed in support of clearing criminal records, or I believe there was one case, they were fighting fines that were imposed on a defendant. So it's just an update to say that we have reviewed those, and staff felt that they were qualifying, so we didn't need to elevate them for committee review.
Okay, so we don't need to vote on approving them or anything like that?
Nope.
Got it.
And we reviewed it with OGC as well, just to confirm, so.
Got it. Any comments or questions from the committee on this agenda item? Seeing no hands raised. Let's go ahead and move to the next agenda item, the action on acceptance or rejection of late submitted applications, which I believe is in our memo. At page 3, if anyone needs a reference.
Yes, so the 2022 ILTA EAF applications were due on May 14th at 5 p.m. We had a few applications come in after the deadline. There were 6 that came in late out of about 100. 5 of those 6 were within 30 minutes of the deadline. One of those came in the following Monday, so the 14th was a Friday. And then we notified the program that their application was late, and they responded promptly on Monday to get it in. As I noted in the memo, with that particular organization, which was Legal Services for Prisoners with Children, they had a misunderstanding that when we gave them an extension to their audit, they thought that it applied as well to the application, which was not accurate. And so once they were made aware, they did take steps immediately to correct the issue and submitted. So yeah, though there were 6 applications, as I said, almost all of them came in shortly after. And I think there could be any number of reasons why there was a few minutes delay. we often have programs that, you know, something's not working at the last minute when they're trying to submit, or they get an error message, or, you know, their internet slows down, or whatever it may be. So we are recommending that all of these applications be accepted for review.
Comments, questions, or concerns?
Question.
Yeah, Herman.
I have a difficulty. What is the purpose of having a deadline if you don't adhere to it? Whenever I think back when all of you applied to law school, the graduate school, there was a deadline. And if you didn't adhere to that deadline, your application was rejected. When I wrote grants for the feds, they had a deadline. I'm on the West Coast, but it was East Coast time. I mean, we've had this discussion before, but if you have a 5 o'clock deadline and I submit it at 6 o'clock, what happens to those other 94 organizations that got it to you by 5 o'clock? Is that fair to them? And that's just my concern. And I know that some will say that all these organizations are important, they're doing good work. But if 5 o'clock is 5 o'clock, then 5 o'clock is 5 o'clock. If 5 o'clock is not 5 o'clock, just say submit it when you want to.
Thanks, Herman. Yeah. Dawn, you had your hand raised.
Yeah, I mean, this is something our staff, we talk about every year because it happens. There's always a handful. But we do believe that not being funded is too severe of kind of a you know, for it might be a technological issue, or, you know, there's some that are recurring. So what we suggest is that in codification, and this is something we've thrown around in the past before, perhaps maybe a penalty system. Maybe it's not being defunded, but they take a hit on their award, like 10,000 or 5,000, something that's like, you know, it sends a message, but it's less severe than not getting their entire ILT and EF grant. But it just seems like that would be a big impact on the community and the clients that they serve.
But I'll just ask the question, what's the purpose of the deadline?
Yeah. Zahira, you had your hand raised.
Yes, thank you. And I very much appreciate like what staff is struggling with, because it is challenging. It's the organizations, it's whether they can even be reviewed, and it's that front entry door. But there is this, you know, push and pull, and I know that you're all sort of weighing through it to figure out how you make this decision. But you know, the two things kind of come to mind for me. Like the first one is with respect to these, you know, I think being able to have a sense of like why people were late, and having a scale of like, what is the significant reason in terms of why you were late? You know, was it a technological issue? Was it something else? Like, is there like a level of explanation you can provide? And then the other one is like, is there a certain number of times that we do allow it? So for one of them, Senior Citizens Legal Services, it looks like this is their third time. They clearly now know that it doesn't matter, like the deadline doesn't matter, because we're going to still let them in. Now they know that, but there might be another organization that's in another county, that's a smaller entity that doesn't know that they can submit 20 minutes or 30 minutes late and it's still accepted. And they may never hit the send button. And so I do appreciate like having some of these pieces within codification, but then also, I mean, the message seems to already be out there for some of these organizations that they can submit a half hour late and they'll still be allowed in the door. And so I think it's, you know, how do you send, you know, more than a message, but provide something that allows some way that everyone kind of understands what the standard is, you know, even if the penalty, because it used to be a lot of the times when you were submitting for public resources and you had to even submit in person, if you're not there by the time you're supposed to submit, you cannot walk in the door.
Yeah.
And we've all experienced that before. It's like the door is shut, it's 5 o'clock, you can't come in. And it's hard, but it also ensures that people never submit late again.
Yeah. Pamela?
I just had a question about the applicants that are applying. None of them appear to be a novice at this process. So I was wondering what are they finding so difficult about being timely? I understand that with new applicants, they should still be concerned about timeliness, but if this is not a regular occurrence, it's not an anomaly. So what are they finding difficult about being timely?
I think this year, and I don't want to speak for these organizations because I didn't speak to them directly, but before the deadline, we did have some organizations that were having some difficulty. We made some changes to the application that built in validations, and sometimes it would stop you before letting you submit and point out things that were missing, and which was helpful to us to ensure, a complete application. But if the organization didn't realize that they had overlooked something, and then they're, submitting at the deadline and then getting an error message or, an exclamation mark saying, you need to go back and fix whatever section, that may have slowed them down in a way that they weren't used to. I know, for example, in the case of legal services, senior citizens legal services, they are not a new organization, but their executive director is new and perhaps has not had the same experience with having done this repeatedly over the years. So I think this was perhaps that person's first time, even though it's not a new applicant.
Bob?
Thank you. I'm glad the question was asked from, to me, partly a structural viewpoint. If you allow somebody to submit their application Monday when the deadline was 5 p.m. Friday, how much can that formal delay on a precise statistical requirement be used to say, oops, I forgot this part of my financial statements. Oops, I forgot this part of the required audit. I just don't like the fact that we are saying what you applicants are doing is such a good service. We'll just, slide by, bend, ignore the timing rules. I know, I understand, I can accept that there can be, I will say, software glitches. You saw or experienced earlier today my difficulty getting in. Well, so for a first-time agency, that may be something that they should advance as a request rather than us saying, hey, did you have difficulty? But when it's a three-time agency, even though it's a new executive director, there's other people on the staff who've been doing this, who've been preparing that material. The executive director did not do all this on his own. Other people out there should have said, hey, we got to get this in by 5 p.m. Friday. And so to me, that it's a new executive director, so what?
But Bob, for that organization, it is the executive director. We know that it's a very short staff. The executive director is the person that's doing it themselves.
Okay, well, it would have helped if you'd said that earlier when you mentioned new executive director, because you're allowing us to think that there's other staff who've been on part of this as opposed to new director, new process situation. So with some applications, it may be, and I think I suggested this earlier, at the very top of the application, must be submitted by 5 p.m. Friday, the blah, 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 and have it in red, have it in boldface. Don't have it somewhere down at the bottom of a paragraph on the third page. Right up top, just make it blatantly clear.
It is, Bob, and we send out reminders. It's not hidden anywhere. It's not
okay.
a date that we.
Well, if it's so clear, and somebody submits it on Monday, I'm just not comfortable giving them a figurative pass or exemption from the timeline. And
Okay.
again, I'm saying, there can be software glitches. Let them state that.
Okay. Yeah.
We're doing their work. They should be doing their work.
Okay, I want to make sure because there's a few more comments and we want to keep an eye on time. Thank you, Bob, for your comments on that. Selena, you had your hand raised?
Sure, and I'll keep it short. I think we have this conversation, kind of year after year regarding the deadlines. And I think what usually comes up at some point in the conversation with commissioners is that the ultimate impact is on the client served. And many of these organizations are quite small, or they provide services to a rural pocket of the community that doesn't otherwise have any services from other IULTA funded programs. And, having a slightly delayed, except for the Monday one, all of them were about within 30 minutes late. And I think there are technical glitches. And even though I, as an executive director, always try to put in my own applications really early, sometimes there'll be someone on vacation. I'm just trying to get one more piece of thing. And with the new built-in features of having verification of additional pieces, there could have been a delay that people didn't realize until 4:30 when they tried to press submit. And so I think that, if the commission wants to move toward a very, very firm deadline at 5 p.m., the impact is not necessarily on the program, it's on the client. So it's not the same as a law school application, or even, when we were in law school, we could get extensions on our papers, usually not on final exams, but usually on papers. And so, there's a bit of a kindness in the fiduciary responsibility, because it's fiduciary responsibility for the grants that you give for the benefit of the client served, not for the benefit of the organization. So, I always welcome this discussion because I think people bring up some very valid points, but I usually defer to staff recommendations at this point in reading their analysis. And I think that staff has done a really great job of saying why the organizations were delayed, if they were delayed, and then working to rectify that in the future. I think that I personally, as working with this entire community, if every year there were 20 organizations that were late and they were a week late or more, and they just said, oh, sorry, we're a week late, that would feel very different from the organizations that say, sorry, we had a glitch, we got it as soon as possible. Or in the instance of the Monday program, they legitimately misunderstood the extension that was granted. So just want to raise the issue that the impact is on clients, not on the organization. And it would really make a difference for the clients in these, especially in the rural pockets that might not be able to get the same kind of services.
Thanks, Lena. Kim, then Zahira, and then Pam. I don't know if your hand is up again or. Okay. So Kim and then Zahira.
I think that this discussion comes up at least once a year. I really don't think that the commission should spend the amount of time it is when there are more substantive areas. I get the importance of procedural requirements. When I look at this list and see that people turned their stuff in within 30 minutes of the deadline, other than this one program, Legal Services for Prisoners with Children, and then it's only a small handful of the entire programs that are funded. I just think that we're spending way too much time going over this every year. And I really want to support Selena's statement, which is, who suffers, which is ultimately the people who are receiving services. And in terms of repercussions, are you not going to fund a program because they turned in their documents 20 minutes late? That just strikes me as really unreasonable, unjustified, out of proportion to, the failure to turn it in on time. It's possible to have some, bright lines, and if you turn it in 30 minutes late, then a certain percentage of their funding is cut. But I really think that this this over analysis of why are people turning in through things late, every year we go over this. I mean, stuff happens. People have problems on the computer. We've gone over all the excuses, and I accept them. They're real excuses. And there's a whole lot of people running legal services programs that are at the top because they want the salary increase, and they've risen up through the programs, but they're not necessarily administrators, and they don't have MBAs, and they haven't necessarily run programs before. It's kind of the world of nonprofit. So, I mean, I'll not keep going over this, but I just think this harsh idea is just not appropriate for these organizations. But I mean, I'm happy to agree to send it to rules to consider whether there is going to be some bright line. But overall, I think that the programs do really well in turning in all of the documents. They have massive amount of things to submit to the Legal Services Corporation. You know, this is just one funding source. So I don't think any of these should be penalized for turning their application in, you know, within 30 minutes late.
Okay, thank you, Kim. Zahira and then Herman.
Thank you. You know, I just think in terms of this, like I'm not in disagreement with some of the things that are being said. I think the distinction are two things. The first one is that we're assuming the reasons as to why people are doing things. We should just ask them. If you want an extension for something, you ask for it and you tell people why you need it. And so in this case, we should be asking people, like, if you turned it in, why late? Why was it turned in late? And then have a review in terms of like why it was turned in late. The second, and I think that would also signal that for an organization that, yes, it's a new executive director, but there are, you know, board members, there are others who are part of that entity. Because if there's not a structure to that entity, then we really need to reconsider, you know, the nonprofit and the health of that entity as a whole, more broadly, if there's a deeper concern that's there. And so I think that there's still this piece of like, you have to kind of like having some level of communication so that there is this piece in terms of everyone else kind of knew when to do it. And when you're asking for something that's essentially an exception, then you explain like why you need that exception. And it may be that you had technical glitches, but being able to have that discussion, have that level of communication around it. The second piece is that I completely agree that it is clients who are the ones who suffer. And these organizations are delivering legal services. The court requires things to be on time. And if you don't have things on time, then you need to go and present to the court, explain why you didn't have something in on time. And so I think that for these organizations, they know that things need to be timely. They know that they're supposed to operate in a certain way. This is very different than if we were distributing money for entities that do something that is a lot less precise than law, and that requires fewer rules associated with it. And so I do think that it's the clients who suffer. And so with these organizations, you know, being able to even communicate something back to them, because that's also part of their work and how the quality of work that they're ultimately doing is to ensure that they're doing work where they're abiding by the rules. This just happens to be one of those rules. It's almost in those instances where you put rules and things in contracts, not to ensure that someone's actually done the small minor thing that you did in the contract, but it then illustrates whether or not they did the bigger things within that contract, if you can do the thing that you actually can see. Okay. And so I don't think that kind of focusing it on like, well, this is minor, it's really more of like, how is this indicative of something else that's going on within the organization? And this is just one data point for us to understand that. And the first part I suggested in terms of just having organizations just explain it. You know, if they're going to be late, give an explanation in terms of that lateness. And so what we're doing is then accepting it and excusing it rather than giving a pass at the beginning.
Okay, thank you, Zahira. Let's go Herman, Dwan, and then I think we need to like make a decision and like do a vote on this one way or the other. So because I want to be thoughtful on time. So go ahead, Herman.
Yep. We have this conversation every year and we move on and say, okay, it's okay. And Selena and Kim, I understand what you're saying, but the question I ask is, these organizations don't see the value of responding to a deadline for one of the organizations that providing them resources. Do they always provide quality service to clients? If we're not going to adhere to the deadline, then I don't think we should put a deadline in. We should just say, get it in around such and such a time. And then if people have issues with staff bringing this to our attention, staff should just ignore it and just accept all the applications whenever they come in. But I think if we're going to put a deadline, let's adhere to that. If you don't have standards, then what do you have?
Thanks, Herman. Dwan?
So I do think like our office has, we're a little bit of enablers in that we don't shut off that button to submit at 5, and we do it on purpose because sometimes there is a technical glitch and sometimes the lateness is very minor, 10 minutes, 5 minutes. And I have this conversation with staff every year. When should we hit off the submit button? I think this past year we hit the submit button off. I don't think they can be on 10 o'clock because, you know, we're off at around 5, 6. What we can do next year is say in an email communication really early on that we're going to take, it's a, 5 and you will not be able to submit after 5. And then at that point, if they choose to, they have to email us and then we can make them submit an application and then reopen the submit button to them. I do think it's going to cause us, staff, more work, but if that makes you all feel more comfortable, we're happy to do that. It's to cut the submit button right at 5.
Okay, I guess we have a Catherine, go ahead. And then I do want us to move to like making a determination on this. Go ahead. Catherine, you're.
I know. I have this hard to fix. I actually was just going to make a motion to approve the submissions for this year and to request that the staff develop a protocol by which people proactively have to explain the reasons it's delayed and then, advise whether that reason's acceptable. And maybe the details of that get worked out later on, because I think staff should have some discretion for a period of time and take more serious things to us so we don't have to consider every single one of them. And maybe that's the rules. I'm always a little confused about what goes to rules and what we can just decide. But I feel like apparently we have not been clear that 5 means 5. So it seems a little odd to this year to say, sorry, your application's going to be denied because it's late. But I do think there's a value in being clear about what the deadline is. And as was suggested by several people, requiring people to proactively just explain why it was late. And there can be good reasons for things being late. So we should consider those. So my motion is to accept and to develop a process by which applicants have to explain if something's late and kind of the parameters around who's going to approve those late exceptions, so that since this is my first experience doing this, we don't have to spend 30 minutes next year having the same discussion about what we might do.
Okay, thank you.
I'll second it.
Who seconded? Sorry.
Zahira.
Okay, so the motion is we approve the current ones that are late and instruct staff to come up with a protocol for next year to make this a more clear thing. It's seconded.
I think it's more clear, but with programs needing to offer an explanation as to why it was late, right? I think that's the piece that's missing. There's we're assuming there's reasons and we don't know what they are, right? So
yeah,
thank
you. Some justification.
Yes.
Okay, just really quick, I wanted a point of just information. The default is that these are not accepted unless we approve a motion accepting them, correct?
Yes.
Okay, just checking. Okay, I guess we will take a roll call vote.
Connolly?
This is a hard one, but yes.
Cloggy? Fightmaster?
Yes.
Bennett?
No.
Blakemore?
Yes.
DeBose?
No.
Delfino?
Yes.
Friedman? Mann?
Yes.
Meeker?
Yes.
Lantold?
No.
Savage?
Yes.
The motion passes.
I will note, given this discussion, that Selena, it might behoove you to communicate with the community that these deadlines are becoming something they have been a concern of ours for a while, and that we are not likely to continue to be as flexible about it. So I'd like to make sure they're on notice of this, but obviously there are exceptions, but I think we need to start giving them the notice now, because I think that's a lot of the issue here.
I'm happy to support staff in that way to amplify their requests that things be submitted timely, and if there's a delay, it needs to be clearly explained why.
Great, thanks. Herman.
the vote passed, but the thing that I'm still have concern, if I as an organization submit my application after 5 o'clock, then you're gonna come to me and say, tell me why you submitted your application late? Are we really looking at holding people accountable for that time? At 5 o'clock, if we shut it off, isn't it off? Or if I submit after 5, I can say, okay, Don, this is the reason I'm late. I mean, what is the message that you're really sending?
So how about let me and Erica Carroll develop something and bring it to you. Let us think a little bit more how it would actually practically play out. And then
why not just shut it off at 5 o'clock if that's what the application says?
Because that wasn't the motion that was passed, I suppose, not to be hard about it, but I actually want to think through what is a reasonable process. I mean, from being a legal services director, I think I always got mine in on time. So but I was a much bigger organization, and I think there might be reasons. So I don't know what those are, but I at least want to have the discussion, not within the moment of approving or denying things, but to sort of say, if it's 5 o'clock and you have to proactively submit something that tells us why it's late, and then we decide we're granting yours, that may be a perfectly reasonable process. And I think we'll be changing the number of things that end up getting filed late because people don't really want to have to tell the bar.
Since I've been here, this has been the pattern. People submit applications late. We have discussions. We say it's going to impact the community. Therefore, we don't adhere to the deadline. I mean, that's been the pattern since I've been here.
I agree with you, Herman. I think we need, here's what I think needs to happen on this issue. I think Erica and Duan need to come up with, we'd like you guys to come up with some protocol, and we should have a meeting, not when we're trying to consider late applications, to set this new standard. Would that make sense to you, Herman?
What you're saying, Erica, what you're saying is that if we have a deadline at 5 o'clock and Herman's organization, for whatever reason, doesn't meet that deadline, Herman has the opportunity to write and say, this is why I didn't meet that deadline. What is the purpose of having a deadline?
Because I think the idea is if they don't have a good excuse, then they don't get approved. And now
you're just creating more work for staff, because now they have to sit and read through this to see why this organization did not adhere to what 5 o'clock was.
Okay.
I mean, to me at least, you're just making the process more complicated. If 5 o'clock is 5 o'clock, let 5 o'clock be 5 o'clock. If 5 o'clock is not, if 5 o'clock is not 5 o'clock, say to the public, we don't mean 5 o'clock.
I mean, I think we should push it to midnight, to be frank with you, and then we don't have to worry about that. And
I don't care where you push it.
But I agree with you.
But if it's midnight, then midnight's midnight.
I understand. The point is, we have this discussion every time. It's always under the gun because we have people who are like going to lose money at the moment. And I think this is the point at which we need to say, this needs to be taken away from the context of specific organizations losing their money at the moment. We need to set these standards at a separate time. Whether that's in the rules committee or here, I don't care, but we need to come up with something when it's not in the heat of the moment of people losing their money. Because I think that does weigh. I hear you, Herman. So
Herman, let us develop something, and we'll look at the technology piece, and just let us bring it back one more time.
But what you're doing, Don, and I appreciate you taking the time to, you're saying 5 o'clock still doesn't mean 5 o'clock. Midnight still doesn't. If that's the case, then let's say that.
Then that's what we're going to try and come up with as a protocol. You're right. I agree with you. That might be the ultimate protocol, but that's what we need to have that discussion on in a separate context, I think. So at this point, I hear you. We can talk offline and then have further conversations on this, but we're at 11:25. We got another late submission issue that we got to debate. So why don't we move to that? And then we can, I do want to have this discussion further on this issue because I agree with you. All right, let's move to the next agenda item, which is the extension request for audited and reviewed financial statements.
Thank you. So audited and reviewed financial statements are an essential component of the ILTEAF applications because we need to be able to compare them with the qualified expenditures reported by the organization, which determines their allocation. This year, staff had authority, which was delegated by the commission previously, to grant extensions through May 31st. Even though the application was due on the 14th, we could grant audit extensions through the end of the month. Anything beyond that date requires this committee's review. So we had 7 organizations ask for an extension, and then we had 2 organizations, one that was requesting more time to submit the correct type of audit. They had submitted a financial review, but those are only allowed for organizations with gross corporate expenditures at or below $500,000. So one organization needs to submit an audit still, and one organization was asking for a waiver. And we included in your meeting materials the written requests from each of those organizations and their explanations as to why they needed an extension. Having reviewed those requests, staff is recommending that the audit extensions be granted, as well as for Riverside Legal Aid, which they did submit a financial review, but to give them more time to correct it and submit an audit. The only one we are not recommending is the Center for Immigrant Protection. They wanted a waiver of their financial review, and we don't recommend that because it is a firm requirement of the application. And even if we could waive it, wouldn't recommend that because it wouldn't be fair to other applicants. So we had recommended in the memo just granting one final deadline of August 2nd. Many organizations have indicated they can get their audits in sooner, but to avoid the need to potentially return this to the committee if an organization experiences a delay, that's why we had recommended August 2nd as the extension deadline for all of these requests, with the exception of Center for Immigrant Protection.
But I do want to underscore what Erica, we're trying to give maximum flexibility, but it does, the staff review time when it comes in on August 2nd is going to be short. It puts us under the gun, but we will do that for programs. I do want to underscore that though. And one of these organizations, for example, Central California Legal Services, they actually have turned in their final audit already. They met the deadline that they set for themselves. But I do know, for example, with Open Door Legal, that I've had their draft for a month, but they've had a hard time getting their auditor to finalize. So they're anticipating the end of this month. I don't know, they can't guarantee that it'll be final by then. So that's kind of why we're taking the longer view, but with the hopes that those organizations that projected an earlier deadline, that they can meet those deadlines. And I'm sorry, I neglected to mention, we do have concerns about Center for Human Rights and Constitutional Law, as well as Family Legal Assistance at Chalk Children's. So though we're generally supportive of an audit extension, we think that the chair of the committee should meet with them first to discuss their requests because they were vague and were submitted late. So.
Thanks, Erica. Selena, you have your hand raised.
Sure, I have a very brief comment, and this is only with respect to working with outside auditors. For the organizations that explain that it's the relationship with the auditor that describes that's the reason for the delay, that they're waiting for an auditor to do something, or they are unable to change auditors right now. I just want to underscore that right now it's very hard to find an auditor for nonprofit organizations. I've been working with a nonprofit that can't get an auditor. A lot of auditors who have worked with nonprofits in the past are, throughout COVID, they have shut their doors, or they've said they're taking no new clients at all. And so many executive directors have reached out to me in the past several months saying, we need a new auditor. Our auditor won't handle our case anymore, our accounting anymore. So I think this is a bit of a struggle, and I'm hoping that it's a temporary struggle specifically because of the COVID related closures. But I feel like this is very much outside the organization's control, because they're really at the kind of under the control of the auditor, saying when they will get something to them, and the much larger for-profit companies can demand the auditor's time more quickly. And so especially the smaller organizations, auditors will say, we'll get to you when we can. So just wanted to give that context for those of you who think that the organizations who they have done something wrong, they may have been trying for weeks and weeks and weeks to try to get the auditor to give them their paperwork.
Thank you, Selena, for that context. Other comments or concerns on this?
Is this Catherine? I just want to, so I guess I was probably more inclined, honestly, just to give people the extension to the date they requested. I'm fine doing it longer. I just always worry about the impact on the bar staff getting their work done and then being able to get the committee and the commission kind of everything in a time that allows us to review it. So I guess I would just appreciate understanding that push and pull and kind of what's easier for bar staff so that you can do your work and then we can get our work. And it doesn't seem like anybody's requesting until August 2nd. So I'm kind of not certain why August 2nd is a magic date if nobody wants that date.
Sure. So the latest date that any organization requested for submission was July 31st, which is a Friday. So August 2nd is the following Monday. So that was sort of the rationale there in terms of like making it a date beyond which everybody hypothetically should be able to get their final audits in. You know, most of these organizations, as I said, in the case of Open Door Legal, I have their draft audit that enables us to start reviewing it. Hypothetically, again, hypothetically, it really shouldn't change from the draft to the final audit. So once the final comes in, it would be more confirming that those numbers are correct. It doesn't prevent us from like reviewing the application at all. So from my perspective, we could still make progress on those applications and follow up on other aspects of the application, and then have the ability to sort of hopefully just confirm and not have any major surprises at that point when it comes in. And it would just be more of a quality check and assurance. But Dwan, I don't know if you have any thoughts on that as well.
Yeah, I mean, when Erica and I spoke, we just thought one consistent date, and instead of, if they come back, they have the target date, whatever, July 10th, and then perhaps they're going to miss it by a few days, then we have to come back to you to ask. So we thought to minimize that back and forth, we give them this firm, and really that needs to be it, because we don't, the state bar rule says that we will not accept beyond when we run the allocation. This committee is meeting to then recommend to the commission the middle of August, late August. So that really is a firm. We don't have flexibility into that. So we figured let's take the August 2nd. That would give staff time to review and bring it to you if there are concerns. But it is, I would again want to underscore, we understand that this year is very hard with auditors, but if there is an issue, it will be hard on staff and for the committee too. With that said, we want to be flexible with programs this year because of everything that's going on. So this is an accommodation given everything.
So thanks, Tuan, for that. So of the ones that are late, what number do we have draft audits for? Which I agree is kind of it's different. And how many don't we have anything for? Because those are sort of more concerning to me, I suppose.
Yeah. Erica, do you have that number? I don't know off the top of my head.
Yeah, so I know we actually have the final for one of these organizations. Open Door Legal, we have a draft. Riverside, we have their reviewed financial statements, so that needs to be updated to an audit, but we do have numbers from them. I think with Center for Human Rights and Constitutional Law and Family Legal Assistance, we don't have anything from them in terms of draft numbers.
We don't even have an estimated date, right, for those two? That's why we want
yeah,
Erica.
Correct. So for Churchill, we don't have a date. I believe they said the first week of July, and similarly, Chalk said mid-July. And then, I'm sorry, I don't know for the others if we have drafts or if we have internal statements at this point. I don't have Western Center. I just have their internally produced statements. I don't have a draft, but for the remaining two, I'm not sure.
So I guess I'll make a motion, some more discussion. I can't actually tell. I just like trying to keep us, since some of us have another meeting soon, or maybe all of us have another meeting soon. I'd just make a motion to accept the staff recommendation of an extension to, is it August 2nd, I think you wanted, and knowing that that's a final date for which there can be no further exceptions.
I'll second.
And then did you want to include as part of that motion that the chair would be delegated authority for the extensions for Human rights.
So delegated authority for additional extensions beyond August?
No, we're recommending that the chair meet with them to determine, one, if the extension is appropriate, and then two, I guess, if that August 2nd deadline or another deadline would be appropriate.
For just the two organizations, for Chalk and Churchill, because they were the ones that have been more difficult to, if they were vague. I mean, Erica's being very nice. They were vague. We don't have a lot of information. We think there might be some underlying concerns to give
So
you.
I'm fine with delegating to Erica the authority to have those discussions. I guess I'm a little confused by part of that. Like, would you give them an extension beyond August 2nd as part of that? Because it sounded like August 2nd's a firm date, which is what I was trying to support in my motion. And then this discussion kind of led to, but it might be about an extension beyond that.
My understanding is that conversations to see if there's other compliance. It's a red flag for other compliance issues, but maybe the two Ericas have more insight into what they envision.
So I think, sorry, my interpretation was that we'd approve it except for those two, and then just delegate me the authority to determine after meeting with them whether they should get the extension to August 2nd. That's
not beyond August 2nd.
Exactly.
Okay.
And not grant them an extension yet until after I meet them.
Okay.
Does that make sense?
So, yes, that makes perfect sense. So the motion is to grant the extension recommendation of, I guess it's just approving what staff recommended, which I understand to be granting an extension to August 2nd for all but the two programs, which is Churla and Open Door, something like that.
It's Chalk and Churchill.
Chalk and Churchill.
Okay, Chalk and Churchill. Funny acronyms. And that Erica has the delegated authority to decide whether or not to grant an extension to August, but no later than August 2nd. Erica Conley.
Yeah.
Right.
Sorry, Jim, you had your hand raised. You're on mute, sorry.
It was mentioned in brief passage, but wasn't there also part of the staff recommendation, was it an organization asked for an exception that they didn't have to submit anything at all?
Oh, yeah.
And I just wanted to make sure that's part of the motion.
Okay, I didn't know if you wanted to take it separately, but yes, if you want to include it in this motion, we can.
Okay, so we'll do an omnibus motion, it sounds like. Catherine, is that okay to amend your motion?
Perfect, thank you, Jim.
So the amendment would be to deny the Center for Immigrant Protection their request to waive the.
Oh, can we actually do that for clean? I'm sorry, and I'm thinking of it because it's going to be an actual denial. Can we do clean?
Okay.
Do the other motion and let's talk about this before we because that's actually an eligibility. Like they're not going to get funding, so it's a bit more. The stakes are higher.
Okay, so let's leave that aside. No amendment. We'll go forward with the motion that Catherine already said. The fee waiver is not even on the table. And then who seconded?
I'll re-second.
Okay.
Okay, Kim's gonna re-second. Okay.
Thank you. Connolly?
Yes.
Boggy? Fightmaster?
Yes.
Bennett?
Yes.
Blakemore?
Yes.
DeBose?
Abstain.
Delfino?
Yes.
Friedman? Mann?
Yes.
Meeker?
Yes.
Planthold?
Yes.
Savage?
Yes.
Okay, the motion passes.
Okay, let's handle this waiver issue.
Yes, so just to briefly summarize again, this is a new applicant, the Center for Immigrant Protection. They're a small organization. They were required to submit a financial review because they had expenditures under 500,000. They didn't submit the reviewed financial statement, and when we brought it up to them, they said they were unable to comply and indicated they wanted to seek a waiver. Staff informed them that waivers are not granted, that this is a firm requirement of the application, and they decided to proceed anyway. So our recommendation is that their request for a waiver be denied.
Well, and what that means is that they not only will be denied, effectively, you will be finding them ineligible. That's
correct.
Yeah. But I'm not sure we even have the power to waive. And even if we did, there's good reasons not to waive given that this is important money and we ask for these to ensure that people are doing things the way they're supposed to. Any comments or questions on this issue? Do we have a motion?
I'll make the motion that
Thanks,
we
Lisa.
deny the request for waiver.
I'll second.
Connolly,
Yes.
Boggy, Master,
Yes.
Bennett,
Yes.
Blakemore,
Yes.
DeBose,
Yes.
Delfino,
Yes.
Friedman, Mann,
Yes.
Meeker,
Yes.
Plantle,
Yes.
Savage.
Yes.
The motion passes.
So I just want to also clarify. So what this means is when you go to approve, make your recommendation to the commission in terms of who's found eligible and who's not, that this program, you will effectively recommend that they found not eligible, and then that will go to the commission to confirm that recommendation. So it's not the end for them right now, but that's what it's leading to.
Okay. Thank you. Any other issues on this topic? Erica?
Oh, no, I'm sorry.
Okay. Bob, what's up?
Again, I emailed, I want to make a process comment before we end this meeting.
We're not actually done. We have one more
I
thing,
just
but
want to be
you're
sure
welcome.
that you get that. Thank you.
Yep, I did get it. Okay, if you don't mind, Erica, can we actually skip to the eligibility review conferences and get that handled, just because that actually needs a vote?
Sure.
And then if we have time for the deeming discussion, we'll do that. And Bob's comment.
Yeah. As you all probably saw in the memo, we had 8 new applicants this year for funding in 2022. Staff is still in the process of reviewing those applications, but in the interest of time, I think I'll just focus on the ones that we're recommending for eligibility review conferences. So the first one is Catholic Charities of San Diego. In reviewing their application, staff determined that their qualified expenditures are around 11 or 12%. In order for an organization to be presumed as meeting primary purpose, they need to have qualified expenditures at or above 75%. The commission has approved applications below 75, between 50 and 75 before, and staff informed them of this, that there is no precedent for such a low qualified expenditures amount. They're not disputing the amount of their qualified expenditures, but would like an opportunity, because the state bar rules do say that you can prove primary purpose by any other means, I believe is the word or the phrasing. And so we're recommending a meeting with them to discuss their primary purpose and whether they could be deemed eligible in this application cycle. And one of the other programs is East Bay Family Defenders, which is an organization that applied last year. They do dependency work in the Bay Area. They have qualified expenditures below 75%. I believe it's around 64 or 65. Staff has some concerns about that estimate because they only started income screening in July of 2020, I believe. And due to the pandemic, reported having difficulty getting consistent income information from their clients. And so the numbers they are reporting are essentially an extrapolation of 2 months of full data. They don't have the full year's worth. And so staff just has some concerns or some doubts potentially about the data, and thinks it would be appropriate to take a closer look and have a conversation with that organization. So we're recommending an eligibility review conference for them as well. And then Community Lawyers, Inc. We brought up some questions because they are a returning applicant. They're a very small organization. I believe they have a part-time executive director who's also an attorney and is responsible for complete oversight of the organization, and including, I believe, the legal services supervision. And I think they also have another part-time attorney on staff. So we have some questions related to that. We're still reviewing their application and following up with them. So I don't know if we've identified every question that may emerge from that application. We wanted to bring it to the committee's attention now. We don't have a firm recommendation about whether to schedule an eligibility review conference at this moment, or whether perhaps later in the summer after a fuller review and questions are answered. But those are the three that we wanted to bring to the committee's attention. So we are recommending eligibility review conferences for Catholic Charities and East Bay Family Defenders. And then we're deferring to the committee at this point on Community Lawyers Inc.
Okay. And then do you need authority for other ERCs going forward?
Yeah, we would ask that, that the committee delegate authority to staff, given kind of the timing of meetings and the short remaining time for the review period, that if we identify other eligibility concerns, that the committee delegate us authority to schedule it without waiting until the next meeting.
Okay. Zia?
Thank you. For Community Lawyers Inc., I don't know if that's the organization last year where I went on the eligibility review conference. Is it, Erica?
Yes.
And so I just wonder for that one, I mean, I think that part of what we did as some of the readout or documentation related to that organization were some of the underlying issues that were there. Partially that had to do with like their staffing as well as some other factors. And so I just wonder that as you look at that one, are you also going back and looking at some of the explanation behind last year to see if they've addressed some of those issues?
Yes, we are. And actually the person assigned to that application, I forgot to mention, they told me the other day that they had a conversation with the organization and they said the review conference was very helpful to them last year, and they've done things like update their bylaws and take a look at their governance. And so they are making changes actually in response directly to what was brought to their attention last year. So it does appear that they have taken steps to address it, and I can get more specifics for you on that if you like. So.
Well, thank you for the update.
Any other further comments or questions on this? Okay, do we have a motion approving staff's recommendation?
So moved.
Bob made the motion. Anybody want a second?
Second.
Great.
Is this inclusive of community lawyers? Because
Yes.
we had sort of, okay. Okay.
I assume. Bob, is that okay as part of your
Yes.
motion? Great. Yeah, let's, I think to Zahira's point, it sounds like there were ongoing concerns, so an ERC might be helpful to them.
Okay. Connolly?
Yes.
Okay. Master?
Yes.
Bennett?
Yes.
Blakemore?
Yes.
DeBose?
Yes.
Delfino?
Yes.
Friedman? Mann?
Yes.
Meeker?
Yes.
Plantold?
Yes.
Yes.
So if I could just take 1 second to talk about the logistics of it. I think most of you have participated in eligibility review conferences before, but if you haven't, usually 2 or 3 committee members will join in staff in taking about an hour to speak with the organization and learn more about the eligibility questions that have come up. Staff will prepare a memo for you ahead of time for your review. And then after meeting with the organization and getting the committee members' feedback, we'll bring a memo to the committee to vote on later in the summer about ultimately the question of eligibility and whether to find the applicant eligible. So we will work on creating teams and reach out to you with some dates to if anybody is not available in the next, say, month or so, please let us know. Otherwise, we'll just assume that everybody is potentially able to participate. And so we'll make sure to try and get you the materials in advance for review and start scheduling those in July.
And you know, because we have 2 returning applicants, it might make sense for at least one person from the last ERC that participated, 1 committee member. So there's some continuity. That would be great. So if you have particular preference, email Erica. If not, then we'll try to make a match.
Thank you. Pam, you have your hand raised?
Okay, ERC deadlines are going to be?
Well, we'll need to have the opportunity to meet with them and prepare a memo before the final meeting on August 13th. So we'll be scheduling them anytime between now and I would say the end of July, hopefully, you know, mid-July.
Okay, so the ERCs won't impact their funding for this fiscal year, or is this for a later, for 2020 that we're discussing?
This
Or
is for
this
2022. It's just for
2022?
2020. So
Okay.
all of these are new applicants, so they don't receive current funding. So it's forward looking at their eligibility for the next year.
Okay, so we'll do deeming and then Bob's issue, and then hopefully we can get out a few minutes early before our next. I have to go to a deposition, but the next meeting.
Yes, so this doesn't require a vote. It's just an update on the deeming process. So support centers that were not in existence prior to December 31st, 1980, every year they need to be deemed of special need by the Qualified Legal Services Projects. This year we have 4 organizations: California Advocates for Nursing Home Reform, California Women's Law Center, Public Interest Law Project, and WorkSafe, which are going to be going through that balloting process. So we are planning on releasing the ballots to the QLSPs on July 6th, and they'll be due back on August 3rd. So we'll have the results for the committee at the August 13th meeting.
Great. Thank you. Bob, you had a comment about procedure?
Okay, early in the meeting, an item was taken out of order and discussed. During that discussion with one applicant, there was mention, oh, a similar thing happened with CRLA. Then the specific reasons or claims for a delay and exemption that CRLA advanced were mentioned. I know that may be part of a public record, but I still think discretion should have not brought that exemption request specifics into the discussion. Maybe mentioning another agency had a similar problem, but it gives the applicant who was discussing it with us an information source to go look at CRLA, to call them and ask them specifically. So we're giving them a hint by that, if you will, informal, ad hoc, spontaneous expression about CRLA, and worse, more so, about why CRLA requested what they did. I don't like it. And I suggest it would be better to temper some of our, I will say, enthusiasm and attempt in our discussions to not always be spontaneous with bringing up other agencies, especially other agencies' requests. It just gives a tip off to the then requesting agency where they can go for how to get around whatever was the problem they're encountering now. That's it. Thank you.
Just a couple of points to note is CRLA's application was considered in the public meeting at the same time as advancing, as Asian Americans Advancing Justice. So I think that tip-off was already there. And I think the other reason it was brought up is because to the extent we reconsider Asian Americans Advancing Justice, that may have an impact on CRLA's thing. And we want to obviously try to be consistent. So
it's not that CRLA was brought up. It's the reasons that CRLA advanced. That's to me the more problematic mention. That CRLA was mentioned in the same meeting, fine. But then what CRLA asked for and did would not be readily brought to mind. It's not part of normal memory. And that's where I just think I would have preferred, or I suggest a little bit more caution, discretion, delay in mentioning another agency's process for requesting exemption or delay.
Got it. Thank you, Bob. Selena and Kim, you guys have some comments?
just directly in response to Bob, I wasn't aware who made the comment about CRLA, but I did share the materials from the public meeting materials with Asian Americans Advancing Justice LA, because they asked for, what other organizations had similarly non-allowable ILAW expenses. So they were already aware of the staff memo on that, and they were already aware that they were one of 2 organizations that were doing census work. So I don't think that anything that was shared in this meeting was not a part of the public record, and they had access to that already.
Kim, did you have a comment?
Well, my only comment is, I think what Bob is saying, despite that it's public record, that we should use discretion when we engage in these discussions. And I think, these are public meetings, and I don't quite recall the scope of when we can go into closed session, but there are times at which there would be, I think, a more free or open discussion when we're getting into certain points where, I think people might be more at ease. Thank you.
Yeah, fair enough. It's a good point both you and Bob are raising, which is, we should be thoughtful about, especially if we're comparing between 2 organizations. And I appreciate Bob raising that point, and thank you for that. Dawn, you have a comment?
Yeah, so I do appreciate you pointing that out, Bob. I was the person that mentioned CRLA in responses to Hiro's question about whether there's another program. It is part of the public records, but I think you make a good point of us being mindful but it is part of the public records, and we just discussed them at length at the last meeting. But I will use more discretion next time.
That it's part of the public record doesn't mean that everybody remembers every damn detail throughout that discussion. That's the point. That
but I do think it was a fair question.
You're talking over me.
Fair question.
You're talking over me. You're talking over me. That is so much detail. You're highlighting something that can be used by another agency. Let them do their research into the public record, not staff, not commissioners, not Selena, not anybody else. Let the applicant agency do their research. If they're looking for a justification for an exemption, extension, or a problem. That's the point.
Thank you for the point on that, and we'll keep that in consideration as we have these discussions going forward. Okay, anything else? All right, we got 3 minutes to enjoy a little lunchtime. I'm going to move to adjourn. I assume no one.
So moved.
Thank you all very, very much. Thank you to staff. And thanks for the hustle today. A very lively discussion, and I'm sure we'll have more discussions on deadlines. And we'll get that resolved hopefully before next year's round. Have a good one.
Okay.
Thank you.
Thank you.